the Secretary of State's office.
Thank you. Good morning. May it please the Court. Richard Coglianese on behalf of Secretary of State Husted. With me at council table on my immediate right is Betsy Schuster, who is Chief Elections Counsel for Secretary Husted, and on my far right is Hal Wallinger from the Attorney General's office. Your Honor, one of the biggest and most important aspects of public service and governmental service is the ability and the requirement to do things in an open and public fashion. And perhaps nothing in governmental service is more important than boards of elections who are tasked with the requirement of counting votes, of setting up the very democratic system of doing all of their business publicly, open, subject to scrutiny. Boards of elections are unique in Ohio law. Boards of elections members are recommended by political parties to the Secretary of State, who then has the authority to appoint. Boards of election members can be removed from office by the Secretary of State for misfeasance, malfeasance, or nonfeasance. Unlike most other bodies in the state of Ohio, boards of elections are bipartisan. 2 members of one political party, 2 members of another political party. The reason that the General Assembly has chosen to set that up that way is to make sure that the confidence of the voters of the state of Ohio in the manner in which their votes are counted is paramount. As I said, another part of that is making sure that the Board of Elections focuses on what the public records, sunshine laws of Ohio are, and carry those out completely and fully, so that when election time comes around, win or lose, everybody is confident in the system itself. For once that confidence is lost, in a sense, our sense of democracy can be lost. The Putnam County Board of Elections was subject to a lawsuit concerning violations of something, as I said, Secretary of State Husted used as fundamental violations of the Public Records Act. Your Honor, you have before you a booklet. I distributed it to the parties. Got 3 tabs, A, B, and C. Under tab A, we have the opinion of the Common Pleas Court of Putnam County in the case of Jeremy Price versus Putnam County Boards of Elections et al., case number 2010 CV 269. I'm going to start by talking about this case. This was a case that was filed against the Putnam County Board of Elections for violating the Open Meetings Public Records Law. Judge Walters of the Putnam County Common Pleas Court stated that, and I quote, "The court determines that the violations of the notice provisions were egregious, repeated, and deprived the public of information that they were required to provide." That was his conclusion. Here's how he got there. He started by determining that on May 3rd, 2008, the Board of Elections failed to give proper notice for an emergency meeting, and because the matter exceeded the scope to the special meeting, there is a violation of the Sunshine Law.
Can I just stop for a second, just so the record reflects? There are 3 tabs in this. Which one are you reading from?
I'm reading from tab A.
Okay.
And
sorry.
That's okay, and I apologize, Your Honor. Continuing in tab A, on July 2, 2008, the judge determined and says, "The court determines that discussions of unnamed topics supposedly carried over from previous meetings does not constitute sufficient notice under the Sunshine Law." The court found another violation there. He continued, and again to tab A, on the 3rd page, July 14, 2008. The court said, the court determines that it is insufficient notice to bootstrap topics by simply referring to matters carried over from preceding meetings. Because the board addressed matters outside of the approval of poll workers, which was what the notice was for, there was a violation of the Sunshine Law. For the August 13, 2008 meeting, the court determined the board went into executive session to discuss personnel matters. The board concedes that this constitutes a technical violation of the Sunshine Law, and because personal matters were not noticed as a purpose for the special meeting, the action constitutes a violation of the Sunshine Law as well. Again, on page 3 of Exhibit A, the court continues September 11, 2008. Because the action taken at this meeting exceeded the scope of the notice, there was a violation, again, of the Sunshine Law. Continuing to September 18th, on page 3 of Exhibit A, the court found, after a stated purpose of the meeting was to prove general election ballots, the court says, the ballots were not ready, and instead of adjourning the meeting, the board conducted substantial other business that they conceived was a violation of the Sunshine Law. Continuing on to page 4, the meeting of October 6, 2008, the court says, the board conducted substantial other business, including the termination of the director and appointment of her replacement. The board concedes that this action is in violation of the Sunshine Law. The next meeting, October 21st, 2008, the court states, again on page 4 of Exhibit A, the board concedes that the action taken at this meeting of moving funds between accounts exceeded the scope of the notice given, and therefore constitutes a violation. It continues to November 12, 2008, where the court states, the board again went into executive session to discuss personnel matters. The board concedes that this is insufficient notice as required by law, but contends at the time that they had good faith belief that it was sufficient. This constitutes a technical violation of the Sunshine Law. Again, Exhibit A, page 4, November 25th, 2008, the court stated, at this meeting, the board went into executive session to discuss personnel matters. The board concedes that this is insufficient notice as required by law, but contends that at the time they had good faith belief it was sufficient. This constitutes a technical violation of the Sunshine Law. On page 5 of Exhibit A, December 9, 2008, the first issue is the conceded technical violation of the requirement to state a specific purpose for going into the executive session. The court finds a technical violation here as before. The next meeting, December 18, 2008, page 5 of Exhibit A, the court states, after the interviews, the board met and discussed subsequent procedures of bringing back 2 of the applicants for further interviews. This conduct of official business without notice constitutes a violation of the notice provisions of the Sunshine Law. January 8, 2009, page 5, Exhibit A. Item 4, discussion of printers was not, however, included in the notice and therefore is a violation, again, Your Honor, of the Sunshine Law. January 15, 2009, the court states, as before, the board concedes that there was a technical violation of the Sunshine Law because they failed to state a specific reason for going into executive session. On page 6 of Exhibit A, September 1, 2010, the court states, on this date, the board went into executive session with Putnam County Auditor Robert Benroth to discuss the preliminary findings of the 2009 audit of the Board of Elections, which had not yet been publicly released. The court determines in the last sentence, it states, the court therefore finds that this was a violation of the Sunshine Law in that respect. On page 7, the court issued an injunction that states as follows. The board violated the notice requirements of the law on the following occasions: March 3, 2008, July 2, 2008, July 14, 2008, September 11, 2008, September 18, 2008, October 6, 2008, October 21, 2008, December 18, 2008, and January 8, 2009. This constitutes 9 violations. The court continues. The board violated the purpose of executive session requirements of the law on the following occasions. March 4, 2008, August 13, 2008, September 11, 2008, November 12, 2008, November 25, 2008, December 9, 2008, January 15, 2009, and September 1, 2010.